Good evening, voters. The issue that we're picking up today is extremely important. Now, the Supreme Court of India feels that a stage has come where it needs to examine whether or not there should be a media gag on litigants and lawyers in pending cases. Now, the Supreme Court order came after contempt of court petitions were filed by Attorney General K.K. Venugopal and the Centre against Prashant Bhushan for certain tweets challenging the appointment of M. Nageshwar Rao as the interim CBI director. Now, in the aftermath of all this, 15 eminent people, including the likes of Arun Shourie and N. Ram, have filed 2 petitions in the top court saying that any such move by the Supreme Court would mean curbing the freedom of speech and that this would amount to muzzling the media and denying the public their fundamental right to information. But why is this important? Because this raises a whole host of questions. Firstly, isn't transparency in courtroom processes a way of strengthening institutions? The fact that the Supreme Court has raised this issue, doesn't that mean that the Supreme Court is upset at the way legal cases are being discussed? So tonight we're asking, why does the top court feel the need to potentially impose such curbs? Is there really a need at this point to put in place these kind of curbs? And should reportage and reporting on court proceedings itself be clamped down on? Should there be some sort of curbs on that? Let me introduce the guests that are joining me tonight. Gaurang Kant, a lawyer of Supreme Court, Anup George Chaudhary, former Advocate General Madhya Pradesh, Gautam Mukherjee, senior journalist, Kailash Vasudev, senior advocate of the Supreme Court, Neerja Chaudhary, senior journalist, Pranav Sachdeva, advocate Supreme Court, and Harsh Mandar, a social activist, will join us on the phone line. Thank you to all my guests for joining us. But before we get to our guests, let me go across to Harsh Mandar, who's joining us on the phone line. He is one of the 15 people who has, in fact, filed this petition in the Supreme Court. Harsh Mandar, thank you so much for joining us, taking the time out. I know you're quite busy at the moment, but if you can very quickly take us through the main points that have been highlighted in this particular petition to begin with. All right, we seem to have lost Harsh Mandar, but we'll reconnect with him in just a bit. But let me go across to Gaurang Kant first. Gaurang Kant, let's get your opening comments. We'll go across the panel and get opening comments from everyone first. Gaurang Kant, go ahead. Gaurang Kant, am I audible? All right. Neerja Chaudhary, if you can hear me, can we have your comments on this entire issue first?
Look, I would make a couple of points broadly. One, that it is very important that a citizen's voice and rights are supreme in a democracy and should be treated like that. Of course, there are limitations to it, but those are very clearly specified in areas of security, etc. Now, in this case, it is not an area of security involved. Now, suppose hypothetically speaking, Mr. Prashant Bhushan made a mistake. I think you can ride it. But if you have the Attorney General and if you have the government come up with a contempt petition against him, what is the implicit message that you're getting across? The implicit message is anybody who speaks up can have problems and there'll be the might of the state or the government against them. Now, Prashant Bhushan is well endowed. He's a lawyer himself. He can fight his cases. There are 10 people standing by his side, but others may not have those kind of advantages. So it will be a message to them, do not speak up, as used to happen and as according to the rights that have been granted. So my short point is, then when it is a fight against the citizen, pitted against the government, I would like to err on the side of the citizen. And if it is a fight against freedom of the government and the freedom of the citizens, or freedom or not freedom, I would like to err on the side of more freedom than curbing freedom. That's in general what, I think in a democracy we should ensure, and the court should ensure that.
Right. Kailash Vasudev, do you agree with that? Do you believe that we are at a stage today where we do need to impose certain restrictions, if not, maybe not an entire gag, so to speak, but certain kind of restrictions do need to be imposed? Do you believe that?
Good evening. In today's system, we have a very, very fine system on all sides. Everybody wants to be heard. Everybody wants to comment. Sometimes the comments are sensible, sometimes they are rash, sometimes they are brash. So keep this in mind and let's proceed on your debate. The Supreme Court is a body constitutionally created to protect rights of everybody. It is, in the terms of the judicial system which we process and which we profess, an institution which is open to punish for contempt. But in that one, there are restrictions on the powers of the court, self-imposed by it. In 1965, it happened in a very big way, but no, without going into the history. When the Supreme Court said the power to punish for contempt, though powerful, should be exercised sparingly. It is the judgments who should speak for themselves, and the fairness of the court should be judged by the people in the right perspective. If the Supreme Court has taken the view that it is to be judged by its judgment and not to be vilified in other manners, the judges have expressed themselves in very clear terms that the rights of the citizen and the right to fair comment is available to everybody. Today, as I said in the beginning, we are now opening up a Pandora's box by making comments of all sorts against the judicial system. What Prashant has done is, he has brought forward a situation where he says he didn't know about a certain situation, and he's put it on record. He's asked for the recall of an order of February. Now, these areas go into very thin lines because there's a difference between contempt and libel. Libel is available to you when you've made a malicious statement and you're liable to be sued. Contempt is available when you have committed a willful default of an order of the court or acted in a manner contumacious to it. If that is the situation, the court will take its course. But in my view, holding somebody for contempt on the basis of a criticism is treading into an area where you'll be circumspecting the rights of people, restricting them and asking them to toe the line, which has just been said by Nirja. The court should be open to criticism, should accept it, and clarify its position by the judgment which it pronounces, not by holding somebody to contempt. That would be the correctness in the judicial system. The judicial system is the last recourse available to the citizen, and it should show it by an example. That is my view.
Right. Pranav Sachdeva, let me come to you here, your opinion on this issue, because the other part, of course, is the fact that the Supreme Court itself has felt the need to raise this particular issue, to even examine it, whether or not such kind of curbs need to be imposed. Isn't that quite telling of how upset perhaps it is at the way certain cases are being dealt with, at the way certain cases are being put forth in a public platform?
See, Supreme Court is an institution of governance. Just like we have a right to comment on the government or the parliament, we have a right to comment on the judiciary itself. Now, judiciary is dealing with large number of cases. Let's look at the Rafale scam. Just because somebody goes and files a petition, can you say that no, there should be no reporting on that? If the judgment contains certain errors, which the government also points out, should that not be reported? The government is not questioning those people who are in the Ram Janam Bhoomi matter. Everybody on the litigant side are going to the media, and the media is talking about it. The government is not worried about that. It is only when the government is questioned, you want to invoke the contempt jurisdiction. Now that itself is quite absurd, because Supreme Court in a large number of cases had itself held that courts are meant to be open, courts are meant for the public. Public has a right to enter the court, has a right to view the proceedings, has a right to comment on the proceedings. Their orders in public interest litigations are affecting a large number of people. Now, can anybody say that that the orders need not be reported? Recently, Supreme Court ordered that all the about 1 million tribals should be evicted. Now, that was the issue which was reported and then the governments also woke up to the issue. So here, what the Attorney General is trying to do is to say that you should punish Prashant Bhushan for contempt for tweeting against the government, not against the court. There is nothing which says that this will amount to interfere with the administration of justice. It is only that the government was being exposed and you want to invoke the Supreme Court's contempt power. So that itself is absurd.
Right. Gaurang Kant, if my voice is reaching you, do you agree with what Pranav Sachdeva has said?
Well, absolutely not. I think he should actually see the content of the petition which has been filed by the Attorney General. It nowhere actually talks about the government or the tweet which Mr. Bhushan has actually put in the public domain. Is basically he's saying that it is a wrong fact which has been put in the public domain. If the hearing was being done on that very day and Mr. Bhushan was a lawyer and pretty much aware of the ongoing proceedings in the court, I think it was factually wrong on the part of Mr. Bhushan to give an information to public which didn't really transpire in the court proceedings that day. To say that Mr. Kharge has not signed the minutes or to say that he was not privy to that was something which was factually incorrect. And that's exactly what he has stated in his tweet, which is absolutely a false information which is being provided to the court. So I think the court is well within its right to really look into the matter. I will not really comment what exactly the court should do because the matter is still sub judice and we should maintain all kinds of restraint which is possible. So, but ill-informed, media or public or giving wrong facts to people is not really correct. And I think the Supreme Court definitely can look into it and can really see whether there's any contempt which is being made out against Mr. Bhushan or not. And I think everybody should really give the right facts before the court and really not come out and make statements, and especially being a lawyer, I think he should maintain that kind of restraint, before he puts anything in the public domain, whether it is factually correct or not. The minutes have been signed, the high-powered committee minutes have been signed by all the three members who have been there, and one of them is a sitting Supreme Court. Well, he has retired today, but he has been a sitting Supreme Court judge at that point of time when the minutes have actually been signed. So it is sort of a contempt, bringing bad repute not only to the Constitution post of the Attorney General, but also to the Supreme Court judge, and even providing information causing inconvenience in the administration of justice. It's absolutely calls for a contempt, and maybe the court will look into it, but it's too early to really say because the matter is still sub judice. So we'll see how the Supreme Court is going to convene as far as the matter is concerned.
Right. Anup Chaudhary, your view on this the larger issue here that we're talking about, the fact that the Supreme Court is now going to look at whether or not these kind of restrictions, these kind of curbs actually need to be imposed.
Unfortunately, when my friend who just spoke, he doesn't distinguish between wrong facts and contempt. The law of contempt is very clear. Either you disobey an order of the court or you bring down the reputation of the court and do something which affects the majesty of the court. And it's ridiculous. He has only, what did Prashant do?
Interfering in the administration of justice. I think the contempt
1 minute,
is not
please.
only a
Let me
willful
finish. Let me
disobedience
finish.
of an order.
You have no knowledge of the law of contempt.
If we can just allow...
No, this is not a willful disobedience.
If you are really putting the scope
please
of the
don't
contempt
interrupt.
law only to the extent of willful
if you can
disobedience...
just
don't interrupt, please.
Allow Anup Chaudhary to complete. Gaurang Kant, yes, please go ahead.
I did not interrupt when you were talking without understanding the law of contempt. So please let me speak. You may have a different view, most welcome to it, but let others speak as well. See, the question is, first of all, I fully agree with whatever was stated by my friend here, to the extent, initially it was said that where is the question of contempt? Tweet is what? The tweet says that I am informed by Mallikarjun Kharge that such a thing was never discussed and no decision was taken in the high-powered committee. What is wrong in that? That may be factually correct or factually incorrect. That's a different issue altogether. And Kailash very rightly put this thing up. I fully agree with Kailash on this subject. He rightly put it. How is it a contempt? The Supreme Court has been rather more than touchy And of course, the Solicitor General of India, for reasons known best to him, has said, no, I want him to be punished. Even before the notice of contempt is there, he says, I want him to be punished. Although the Attorney General made it very clear. They said, I am not asking for punishment. But the Attorney General had a particular view. I don't agree with it. And I don't think this is a case of contempt at all. No contempt is made out at all. And I say this, I've also been the Advocate General for a state 25 years back. And permission of the Advocate General was required to move the court for contempt. I can say very well that this is not a case of contempt, and the Supreme Court has been rather too touchy and has been moved. Of course, once the Attorney General moves an application, it makes a whole lot of difference. And maybe the court would have probably had a different view if somebody else had moved this application. But the Attorney General of India, for India rather, filing an application must have impelled the court to issue the contempt notice. But there again I see that the government represented by the Solicitor General of India was a little too anxious to ensure that Prashant should be punished. That's what the attitude was, which is, I feel, is not correct at all. If he is a bug, as far as the government is concerned, it's all right. They are there, but you have to take it in a more large-hearted manner. The higher the court, the bigger hearted approach and is required towards things. You can't be so constricted as a smaller court like a lower court or a high court. So right. I personally feel that there's absolutely no, in my opinion, there is no case of contempt at all.
Right. All right, Gautam Mukherjee, your opening comments, because let's face it, in the media, there is often a lot of criticism as far as the media trial by media is concerned, the way things are, certain cases are handled. What is your opinion in light of all of that? What is your opinion?
Well, I've had the good fortune of listening to legal comments from legal luminaries before I got my chance to speak. Now, there are two things here. One is this rather fine point of contempt of court, which I'm sort of in agreement with broadly with some of the others who have spoken before me, who say, well, look, does this amount to that? But it is also some kind of breach of trust in commonsensical terms. If you're a lawyer in that particular case and you go and release bits and pieces, that too incorrect bits and pieces, as Mr. Khan pointed out, to the media. So you've gone and done something which is a bit fast and loose. And the other thing is he collects 10 far left, from almost anarchists to, you know, definitely communists and far left people, 10 of them, one disgruntled former minister of the BJP, people like N. Ram, who makes fast and loose with a government document, edits it, puts it forward, and then refuses to budge. People like Guha Thakurta, who've been nailed or at least have been facing the big guns from people like Reliance, and got chucked out of the Economic and Finance Weekly. The only reasonable guy in that whole mob of 10 people or more is Habibullah, who has probably lent his ballast and given some dignity to those 10-odd people who are trying to back Bhushan. Now, Bhushan is also a person who has elements of separatism about him, backing separatists, being anti-national. You know, it's not just any old group of homogeneous people talking about freedom of expression. Now, just a minute, let me finish. So you've got these kind of people doing this. Now, the Supreme Court, which has been largely appointed by a socialist Congress and, you know, their cohorts who are the communists in Kerala and Bengal, should decide to look at these things, means that it is discomfited. It's had enough of kind of sniping from the side while this is going on. Freedom of expression is a land without boundaries. So perhaps a little bit of comment, if not censure, is called for.
Anup Chaudhary, I saw you nodding your head or shaking your head rather. Would you you wanted to respond?
No, yes. I think this comment of my friend to say that the Supreme Court is appointed by a socialist Congress, that would probably come into the definition of contempt. How can you say that?
You know, it's like, may I say one thing? It's like Henry II appointing Becket.
My
now
friend
when
does
Becket
not know
gets
anything.
in,
Nobody
he wants
is
to
appointed
defend
the
the
Supreme
church.
Court by a socialist Congress. I'm so sorry. You do not know the process of the manner in which a judge is being appointed. It is the collegium which recommends, even if the government does not agree, once the recommendation is reiterated, they are bound to appoint. And for last 20, 25 years, there is no socialist and no Congress appointing the judges. So please correct your facts. Then secondly, where is the question? I would personally not like to pass any
I beg to differ. I beg to differ, but you're entitled to your point.
Now the scope of this discussion that we are going on to, so-and-so is an anarchist, so-and-so is a communist, a very expansive statements being made. And you see, the question is, even if
Indeed, and I stand by them.
Statement is incorrect on facts, that doesn't amount to contempt. That does not amount to contempt. Please, let's not get into a one-to-one arguments on this. You have a view, we are on a national TV. Let's maintain some decorum. The question is not, issue is not that. The issue we are discussing at the moment is the tweet of Prashant Bhushan, does it tantamount to contempt?
Yes.
That's the main issue. Now he has, as I said earlier, and I'm repeating it again, he has attributed his tweet to the information received from Mallikarjun Kharge. Now whether that is right or whether that is wrong, and even if it is wrong, does it amount to contempt? It doesn't amount to contempt at all. Not the way the definition of contempt stands in law as of today.
Right.
Either
Kailash
civil
Vasudev, yes.
or criminal contempt. It's neither.
Yes. Yes, Kailash Vasudev, your hand was up.
Can I respond?
Yes, you can respond. Please go ahead.
Yeah, just a very, very short point. Look, I'm not going to argue with you as a lawyer on the finer points of contempt, but I would like to say one thing, that just as Mr. Gupta of Goldman & Sachs went and picked up the phone and told his friends in the mutual funds all about what was going on, it wasn't, it was later on found to be morally wrong, quite apart from anything else.
Gautam Mukherjee, I'm sorry, I would disagree with you over there. I would disagree with you. It goes much beyond morally wrong. That was done. I think insider information is a completely different point.
No, it's morally wrong if you go and talk about something which is false to the press.
This does not fall into the same category. I think we're going completely off topic here.
And not the court of discussion just now.
Yes, exactly. It's not the scope of discussion. And on top of that, I disagree with the fact that it's just a question of being morally wrong when it comes to insider information. But Kailash Vasudev, you wanted to come in. Please go ahead.
I was coming in for a very different purpose. We are veering away from the main issue,
yes,
whether the Supreme Court should impose restrictions on its reporting. And if reporting exceeds a certain norm, it amounts to contempt. That's what the theme of the whole discussion today is. Now, in the recent past, we have had observations coming from both sides, the bench and the bar, done to control, to regulate proper reporting of cases. In my view, in a free press like ours, we should not have any restrictions. At least court import restrictions, because the court does not know where to draw the line and how far to draw the line. Every case has its own boundaries. You can hit a 4, you can hit a 6, you can get a buck. It all depends on each case. Here we have a situation where the court is expressing its angst over certain developments which it feels has caused loss to its dignity. Now, in this context, personally speaking, again, I repeat, it is not for us in the judicial system, either as lawyers or as courts, to lay down parameters at par with the constitutional restrictions under Article 19. 19 gives the power to the government to impose restrictions on the fundamental rights. But it does not give anybody power to stop free speech. Free speech is to be regulated by all of us in our own correct way and in a manner where we don't offend the other, Because the test of a free speech, the test of a statement is whether you have caused harm or jeopardized somebody's position or entered into the domain of the administration of justice and caused it a certain amount of bruising. So therefore, for the court to come in or for the bar to come in or for the government to come in to restrict anybody is wrong. It would not be acceptable and you won't be able to implement it.
Right.
There are so many orders passed by courts which cannot be implemented. They come in the contempt in the community.
All right. I think we seem to have a problem with Kailash Vasudev's line. We'll try and fix that and come back to him. Meanwhile, let me go across to Neerja Chaudhary. Neerja Chaudhary, the way I see it here, there are two issues that are largely, that are connected here. One is, of course, the entire issue of contempt, which everybody has different opinions on and which perhaps is a discussion in itself as to what amounts to contempt and what doesn't. Where is that line? And the other is the fact of whether or not there is this kind of regulation, there is this kind of need that needs to be examined here when it comes to some sort of a media gag, some sort of regulations that need to be put in place for discussing cases that are currently pending or that are currently sub judice.
I would like to make 2 points here. One, before I go into your question, one of the panelists had a whole lot of words to say about those who have intervened. Now, I think those disparaging remarks about people we may disagree with is not called for. And I may disagree with several of them, and I do. But I recognize that there are people, all of them, who fought for citizens' rights. That I respect about them. I can answer an argument by name calling and then go on to my argument. And those are people who are not here to defend themselves. So I think we should respect that. Point number 2 about the gag. There are enough laws already to regulate that. I don't think we need further curbs to be put. For instance, if you put curbs on issues that are so-called sub judice and are sub judice, then anybody who wants to stop anyone from speaking, they can simply go to court with a PIL, have the matter come up in court, and for the next decade, you just bury it out there, given the time that courts take to adjudicate and come to a final decision. So that's the best way to fix somebody who has a different point of view from me. I think it's a very dangerous trend if we give in to that.
Pranav Sechseva, would you like to come in here? Because, the issue, like Neerja was pointing out about the gag, any kind of a gag really being imposed is obviously not something that any of us would perhaps want. But the truth is that this is an age where you have things like social media, you have, you have TV-savvy litigants, TV-savvy lawyers who are there, who come out and talk and very often diverge from what happened actually in the court and start criticizing and going into other aspects which perhaps is not warranted, which perhaps the court would get upset at.
See, if you want to stop any discussion on an issue which is sub judice, then you would have to stop discussions on all the subjects, because every issue is sub judice in every way, whether it is Aadhaar, whether it is any issue of public importance. Half the newspaper is filled with court reporting. So, and there are designated reporters by the court. So obviously, court also recognizes that their cases will have to be reported. The reason we don't have a jury system, the reason we did away with jury system was jury was getting swayed by the public opinion. Now the judges have to be made of better stuff. If they are getting swayed by public opinion, then the answer is that they should not be watching television or reading newspapers, rather than stopping the discussions on issues of public importance by the citizens at large.
Gaurang Kant, your response?
Well, I think, before I was hearing Mr. Chaudhary, he has almost passed a verdict that there's no contempt which is made out. But I'll again reiterate the point that it is not only the willful disobedience of an order, but it also leads to anywhere interference in the administration of justice or in the course of the judicial process. And I think as far as this debate is concerned, the tweet which has been put forth by Mr. Bhushan, definitely there has been an element of ill-informed news to people and to the media, which really amounts to, in my view, but still the matter is actually sub judice, so I can't really pass any verdict on that. But definitely it must have persuaded the conscience of the court to issue a notice. And the larger picture that whether there should be any restriction or not, yes, people should act in a manner where they are not really putting things, or interfering in the course of justice, which I see in, a leading TV channel had actually put the entire status report filed in an investigating matter before the public, which is not really right, to the extent that you're really interfering in the course of justice. You are bringing in facts before people, which might really hamper the entire investigating process. And the court is also conscious of the fact that the rights of the litigants are something which is very important. So we also need to respect the rights of the litigants. We have to make sure that the reporting which is there is fair and not really harming the interests of the litigants too. So I think some sort of a restraint is definitely required, and we are seeing it. There are a lot of judgments which have been passed. We are also progressive to the extent that we are talking about, relaying it, the live proceedings of, the judicial process. So I think, on one side we are talking of making it more transparent. On the other side, we are talking about restraints and restrictions. But those have to be really seen that what kind of restraints we are talking about. Definitely, it should not hamper the interest or right of any litigant, or to that extent any kind of,
yes,
I think wrong information which is being fed to the media. I think that is something which really needs to be taken care of, but not really complete gag on media reporting, because this really builds the conscience. So I think the judges are definitely above board when it comes to watching TV, and I'm sure they are not really getting swayed, because otherwise we will not really be seeing any justice being done. So I think it is more to do with what law is being violated and what facts are before the court, which really makes them take a decision on any cases. So I think
Gaurav, essentially you're saying that there need to be certain kind of restrictions that put in place to ensure that things don't really go out of hand when it comes to talking about cases that are sub judice. Anup Chaudhary, I saw your hand up. You wanted to respond.
Let's say something here also.
Yes, Anup Chaudhary and then Kailash Vasudev. Yes.
Yeah, of course. See, there's a very clear distinction as to whether it interferes in the administration of justice. Now, the question is that if you are trying to curb the powers of the press, I'm sorry to say that, the Supreme Court is also a creature of the Constitution. And the freedom of speech enshrined in the Constitution is paramount. So I personally feel even the Supreme Court cannot put any gag or any curbs on the press unless, of course, it interferes in the administration of justice. And dissemination of information most certainly does not do that. So there also the Supreme Court has to tread very softly on this issue, because it is a very large issue. It affects our entire democratic system.
Right.
And then only to say, how does it, the interference in the administration of justice is very large. There is even not an iota of allegation that this has interfered in the administration of justice. I'll give you an example. In the Maharashtra, that Bhima Koregaon matter, where the matter was going on in the Supreme Court, the Maharashtra police started releasing all the information to the press from beforehand.
Yes.
Now, that I would submit was directly trying to interfere in the course of justice and trying to influence the court. The court disapproved of it, the Supreme Court. But I think it was very broad approach it had. It cautioned them and disapproved them, but in fact did not issue any notice for contempt.
Right.
Now, if that, I think, was a far more serious matter than the tweet of Prashant Bhushan, for that matter. Therefore, I think we have also, our constitution enshrines equality and equal dispensation of justice to all. So how can you now then try to make a difference? That if the police in Maharashtra released out to the press whatever investigation was going on, which they should keep to themselves, which was in fact indirectly or maybe even directly affecting the case which was being heard by the Supreme Court. What were they trying to do? So even in that case, if the Supreme Court has not taken cognizance from the point of view of contempt and issued any notice, but only cautioned them, here also I think a caution was more than enough.
Right.
The Supreme Court has really jumped the gun by just issuing contempt notices. But there again I said the difference is, because the Attorney General is a high constitutional functionary, and he is for India, and he's the #1 lawyer of this country. So when he moves an application, I don't think that the Supreme Court had any choice, but at least to issue notice.
Right. Well, I am not sure whether the Supreme Court doesn't have a choice in whoever might be the person actually, filing the petition. But
I'm sure the Supreme Court will take a view which is proper.
Right.
And even if whatever it decides is final in any case.
Right, all right, all right. Before I go to Kailash Vasudev, we've got a caller on the line, P. Kumar from Trichy. Hi, P. Kumar, thanks for calling in. Go ahead. What would you like to say?
Yeah, Avni, just give me 2 minutes to put the discussion into perspective. Nobody is doubting, the entire audit of the order of His Majesty should be implemented in letter and spirit, number one. But what had happened is today 40 crore cases. Our great Mr. Anup Chaudhary is sitting over there. Unfortunately, I belong from same place of Jabalpur. So he will tell what is going to happen if media is not allowed to bring a speedy trial. If you see today, Japan and Australia, the judges are playing golf at 3 p.m. because the crime rate is so low and you are having 40 crore cases. Like Nana Chaudhasma has said sometime that do crime, get bail and enjoy the life. 35 years, 40 years, it's happening. So media, there should not be any gag because judiciary is also a part of democracy, third pillar, but media is that fourth pillar and media is doing excellent good job. And due to media pressure, these speedy trials are taking place or 30 years, 40 years, generations after generations are hovering around court. And that is not the case. Yeah, so I request all the learned panel sitting over there that they should come out with a solution that this 40 crore cases has to be solved. And Prashant Bhushan, I only give 10% he is serious. 90% time he wastes the time of the court. So he should not be taken seriously. But these 40 crore cases which are lying in all courts should be addressed and there should be compliance to be taken. Thank you.
All right. Thank you, P. Kumar, for sharing your views on this issue. Kailash Vasudev, yes, please go ahead.
What has happened is, the essential that I was saying when I got cut off was that we are dealing with an issue whether we should put restrictions on the media. My answer is no, you cannot impose. I'll give you a small example. There's a bar in the Criminal Procedure Code and even in the practice that the name of a victim in a rape should not be disclosed. The media in many cases has disclosed the name of the victim, made it public, but the courts have not been able to do anything to muzzle the system because, well, it's happened. Now, what are you going to do about it except hit out a caution? Many a times the media does take advantage of its position because it's got to gain its TRPs, it's got to show its positions that we are going to report this manner. And there's tremendous amount of gusto to report a matter as fast as possible, irrespective of the consequences. In your reporting, you do cause embarrassment to the individuals because often the reporting may be right, sometimes it may be totally wrong. When it gets skewed, it does cause a lot of angst. Reporting and trials by media are not unheard of in any system, nor is it unheard of in our system. If you're going to have a trial by media and permit the media to decide issues, then we will defeat the very purpose of a judicial system. The judicial system has to function independently, without fear or pressure from anybody, and to do its job to the best of its ability. In doing that, the judicial system
All right. Neerja Chaudhary, your hand was up. You wanted to respond?
No, my point is very short point, that the media's job is to inform public opinion.
Yes.
And that is a central thing that we owe it to our viewer, our reader, to inform about any issue to the best of our ability, which should be absolutely correct, objective. But you can sometimes make mistakes. In good faith, you can make mistakes. And I think to say that the person, hypothetically, if he's made a mistake, to say that we will now punish you and make you a message for others, not to do a thing like that, not even to open your mouth. That, as I said at the beginning, between freedom, I would go for more freedom and err on the side of more freedom than curbing freedom.
Right. But Neerja, if I can interrupt you, having said what you're saying, and I perhaps completely agree with you there, the question is then, do we at least need to ensure that there is a certain amount of self-regulation, that we do ensure that the way we present certain cases, the way we present information, the way things are discussed on our platforms are done so in a sensitive manner without ensuring that it doesn't hamper in any way the proceedings of the court?
Absolutely. Not influence the proceedings of the court. Absolutely, I would agree with that. But that does not mean you put in more and more and more curbs and use instruments like contempt to put in those curbs. That is what I'm objecting. There are enough laws in the country to be able to deal with the problems that you have talked about. You don't need more.
Right. All right. I think Gautam Mukherjee has been waiting for a while to make a quick comment. Go ahead. We're running out of time, Gautam Mukherjee. Your comment, please.
Yes, I just, while I am a journalist and as you know, I speak my mind, but I would like to say that there has to be some form of, it's very different 1965 and now, because you've got 24/7 news broadcasting, you've got the internet, you've got streaming, you've got all sorts of creative and news, direct news ways of expressing which side you stand on and what you try to say. Now, there has to be some form of national consensus on what is good for us. You cannot just snipe at everything and bring the whole edifice down in the name of freedom. Nobody allows it. India is probably one of the freest democracies anywhere. And perhaps it's a little chaotic as a consequence. And what do we collectively want to do about it? Not a lot, I would hazard. What is happening is the Supreme Court, which is by no means, as I said earlier, from a right-wing sort of background, because the country wasn't right-wing for 55 or more of our 70 years. Now, not to put too fine a point on what the earlier gentleman said, that, they have a collegium. I understand that, but you come out of the pond you live in. Right. Now, with that, what are we going to do? Now, the Supreme Court is in a wonderful position to issue some guidance. The finer points of contempt. Contempt sounds like a very 19th century or even earlier kind of notion to me.
Right.
So, I mean, that apart, what can the Supreme Court do to help us all come to some kind of behavioral standards, if nothing else?
All right. Essentially, you're saying that the Supreme Court can, in fact, issue certain guidelines as far as this entire situation is concerned. But on that note, we're completely out of time. I'd like to thank all my panelists for sharing their views on this extremely important subject. But viewers, this issue does not end here. The questions still remain. Remember, the Supreme Court is moving towards an era of more transparency in courtrooms. In fact, isn't transparency in courtrooms processes a way of strengthening institutions? The Supreme Court that wanted to open up the courtroom for live broadcasts in specific cases, that same Supreme Court today feels the need to raise this issue, to examine the need to impose certain curbs. In my opinion, that itself is extremely telling of perhaps how agitated the top court could be, and that it is perhaps requires some introspection on part of all the concerned parties as to how cases, especially sensitive cases, are discussed on media platforms. But at the same time, what we found out at the end of this debate, that in a democracy, and what perhaps we all agree with, it's extremely important that the media has the freedom to disseminate information. and that curbing the media in any form or any kind of a media gag order is certainly not the best idea. So we'll of course have to wait for the Supreme Court and see how the Supreme Court deals with this situation. Thanks so much for watching.